Digital transformation has been a priority for years, but the legal industry has scarcely taken notice and is unprepared. The pandemic that we're going through appears to have changed that, and it's likely to produce a swift, comprehensive, top-to-bottom reimagination of legal services, including, for instance, how lawyers commence court actions and close transactions. Standing on all existing protocols from yesterday, particularly as set by my good friend Ozofo Latunde Ogemudia, I would like to make a confession this morning. And that confession comes from how we closed last year's conference. Before we had that conference, the discussion was had whether the program for the conference should be electronic or a paper document. We thrashed out the issue, and very few of us felt we could go digital because there seemed to be a need to have a handy document. Alas, here we are today. And I received an email from one of my friends that was at that meeting that said, Baba, do you recall when we discussed having a digital program? Here we are having a digital e-conference, not a virtual one, as SBL chair said yesterday, but a truly e-conference that reflects our now normal. I wouldn't say it's the next normal, as Astrid Ighodalo mentioned yesterday, but a now normal. When council sat to deliberate on whether this conference should be held at all, and if held, whether electronic, if held, whether virtually, I was completely against holding the conference because I thought we may not be successful. I'm happy to confess here to everybody how wrong I was. We have not only managed to hold it successfully, I've seen the transition or the transitioning from plenary sessions to breakouts to opening remarks by the governor, by the Chief Justice of the Federation, and others, and it's all been seamless. I say a very big well done to the entirety of SBL. And as we speak to you, or as we're going to speak to you today, I have another confession. A number of your panelists today are in Europe. The rest of them are somewhere in Africa, probably Nigeria. Maybe they got stuck, maybe they didn't. But in our now normal of today, we live in what governments presume to be a bordered world. But technology is showing us that we truly are in a borderless world, where some of our practitioners, whether as domestic litigators, international arbitrators, are able to ply their trade from the comfort of their living room, their study, their offices. Truly, we have come into a business unusual phase. Now, please permit me to introduce you to our panelists this morning. I believe two of them require no introduction because they're council members of the SBL. And incidentally, I think this is the first plenary panel that has all lawyers sitting at. And I believe because this is business unusual and an e-conference, all our profiles have been set electronically and have been given. But permit me to please introduce you to George Lubega. George Lubega is a partner at CMS. He's a litigator, a domestic litigator, an international litigator. He's also an arbitrator. He plies his trade in the UK, Europe, and beyond. And his firm, CMS, have also invested in a tech platform that allows collaboration amongst law firms and tech companies. My new friend, Dr. Babatunde Ibidapobe, fondly referred to as Tunde, and I found out that two of my colleagues are actually great friends of his yesterday. The PhD holder in law, practiced law in Nigeria and the UK, practiced both in the public and private sector. He's a techpreneur and a founder of the platform LawPaddy. He's also one of the people behind the platform Access to Justice. He will be sharing his thoughts with us in terms of how technology is able to benefit the legal industry. Mr. Olomola, you need no introduction. As council member, a partner, KPMG, and neither does Anthony Nwaochei, another council member and managing partner, the Law Crest. Ladies and gentlemen, welcome to our session this morning. And George, I'm going to start with you. It's very difficult to travel nowadays, almost impossible to travel from certain jurisdictions. Certainly a country like Nigeria, you can't get out, you can't get in unless you're an evacuee. Now, you're a litigator and you practice arbitration at the same time. And the bulk of the work that you do used to require you to jump on an aeroplane now and again for hearings, for meetings. What's the play? What's going to happen now? What's happening now? From a global perspective, a UK perspective, how successful are you to continue plying this trade? George.
Baba, hopefully you can hear me and everybody else can hear me, and welcome to the session from me as well. So it's an interesting question. I was just reflecting on what you were saying about the ways in which things have changed over the last few months. And one of the things that I think for me as a practitioner over the last nearly 30 years that really surprises me is that since March, since the lockdown in the UK, I haven't printed a single piece of paper from a printer. And I would not have thought, if you'd asked me that in February, whether that was a possibility for me personally, I wouldn't have thought that that was possible. But look, just reflecting on what happened in the UK and Europe during the lockdown, there was an immediate locking down of all hearings and trials, and things really stopped for at least a number of weeks. And very quickly, I think, particularly in the arbitration world, both the judiciary and arbitrators realized that they would have no work. If you like, the wheels of justice would start to grind to a halt. And in the arbitrator's case, being a little bit cynical about it, they would have no income unless they did something about it pretty quickly. And what the courts did was to issue a practice direction in the UK on remote hearings. And what the arbitral institutions have done is to mirror that effectively with guidance on how remote hearings would work. And there have been a lot of objections. A lot of them are practical objections, particularly in relation to things like witness tampering and how you could carry out a trial. And that's been a kind of key question, both for the courts and arbitrators to deal with. But actually, the courts took the view in the UK that they were going to push on. And what has happened is that there were a number of interim hearings in March and April using Skype, Skype for Business, and Zoom, and to a lesser extent, Teams. And they were reasonably successful. And the courts ordered the parties, often against their will, actually to go to trial. Those trials, a lot of them have been held, and the barrister teams have been very quick to tell us, that they have been successful. and we've even had judgments coming out of it. So, and the same is true of arbitration. We had an arbitration which was due to take place in April, and very quickly the arbitral tribunal, LCIA, institutional arbitration, decided that they would try and do it as a remote hearing. Now that hasn't taken place yet, so I haven't seen it, but we've had a number of hearings which have been remote, and they're very similar to the stage here. Everybody can see each other, everybody can talk. For want of a better word, the moderator, the chairman of the tribunal, can control proceedings and can put people into separate rooms and all of those sorts of things. So it's worked relatively well. Where does that leave us? Well, there are some really difficult areas. So, for example, criminal trials. What do you do with a criminal trial? Can you have a jury deliberating? There have been attempts at doing that, and attempts at inclusion. So, for example, jurors who are not tech savvy have been sent laptops and dongles and been given access to the internet to try it out. I think where you end up is probably this. I should mention one of there have been so many practical issues to overcome. So I mentioned a minute ago tampering with witnesses and the concern about tampering with witnesses, and solutions to that have ranged from making the witness sit as I am now, but with a mirror behind them, so that the people in the other room can see that there's nobody in front of them giving them a kind of briefing as to what to say, or making them lift up their laptop and move it around the room periodically in order that people can see that there's nobody else in the room or nobody coaching them. That to me seems a little bit sort of old style in terms of solutions, and they are things that will need to be overcome. But I think where we end up is that people won't be getting on planes as much. So those arbitrators who've liked their sort of first class journeys around the world are not going to get that. Clients are not going to pay for it because they see this stuff and they know that it's just as good or good enough. So I think almost all interim arbitration hearings in international arbitration will move to remote hearings because it's the obvious and sensible thing to do. I think in the court system, a lot of those interim hearings will move to remote hearings. And that has obvious advantages for all of us because, by way of example, for those of us who are litigators, we won't necessarily have to sit in the hallway of a courtroom for 6 hours waiting for our turn to be called or, our turn in the list. It can be done in a much more efficient and sensible way. But I think there is sufficient resistance at the moment, both in the legal community and in the judiciary and amongst arbitrators, that remote trials will not become the norm. There is still that feeling that the sort of face-to-face engagement with a witness is needed if it's possible. We may see more witnesses having their evidence taken remotely, but I think that the trials will still be pretty traditional, actually. So overall, a lot less travel, but I think there still will be a place for it. Baba, I'm not sure that we can hear you at the moment.
Baba, we still can't hear you.
Baba, can you refresh your page? Baba, can you refresh your page? Baba, can you refresh your page?
I think we're still struggling to hear Baba. So I think I can just pick up from what George said. Unfortunately, I'm not a litigator in Nigeria, but I think some of the structural problems that George mentioned, I can just pick up from what George said. I think we have some feedback. So from what George said, the situation in the UK is, I think a lot of that will be mirrored in Nigeria, probably even more so, because for instance, I think coming from an access to justice perspective, I think there's a presumption that all virtual courts are important because we need to still continue. But people don't understand that there's a difference between a virtual court for a litigant who has access, for instance, to a certain level of internet connectivity, or has access to certain other facilities that, for instance, another party might not have. So and I think internet connectivity in Nigeria is a big issue. We have problems with data, we have problems with connectivity in rural areas. And so I think it's a very naive presumption to think that, oh, because virtual courts are allowed now, that they would be effective. I think people need to actually think about the structural things that need to go into place for virtual court hearings to go on. So the things that George has mentioned around witness tampering, those are still relevant in Nigeria. But even if you take 3 steps back, just getting online is a problem. And so it's an issue that has to be kind of tackled from the ground up. And there are different intriguing ways that people can use to try to address that. And I think during the course of the panel discussion, I think those will come to light. So I think Baba is back with us now, so I'll let him continue the session. Unfortunately, Baba, I think we're still having issues with your audio. And I guess
that probably illustrates in itself some of the challenges we may have in a country like Nigeria and in many developing countries where access to the internet is not to be taken for granted. So how do you then have virtual hearings in a secure environment, in a place where you can't even guarantee electricity? I think you'll probably find that for countries like Nigeria, we will initially move into some kind of hybrid situation where service providers would spring up around the country that can provide these secure environments for virtual hearings to take place at a fee. And so their value proposition will be in the infrastructural support that they're able to bring to bear to the benefit of witnesses and parties to lawsuits who themselves may not be able to provide secure environment for such hearings. So I think it's the developments in the world today are moving us in a direction that will lead to creation of new markets, new products, all in a bid to augment and provide a holistic environment for justice sector delivery. And the recent decision by the Supreme Court in the matter brought by Lagos State on virtual hearings, I think is endorsing the direction that things needs to go, and the court should be commended for taking a very early proactive stand in favor of remote hearings. I see Baba is back now, so I yield the floor.
So Baba may be going back and forth. I hope you can hear me now.
Absolutely.
Yes, we can.
God. The challenges of technology and remote hearings. And there I was actually going back to George's statement about, look, in a few seconds, I was off screen. And despite the fact you may have the mirror behind me or not, nothing could have stopped witness tampering in those few seconds and I get back on.
So it will face its challenges, but like most things that are, I don't want, well, I'm going to use the word revolutionary, that are disruptive, you will have some, teething to deal with. And if you told me last year that we would have an electronic program this year, it wasn't going to happen. And here we are. George is in Paris, if I believe. Tunde is in Lagos. I'm not in Nigeria. Mr. Olomola, I believe, is somewhere either in his office or at home. Tony is either on top of NIPO's, above NIPO's building or elsewhere right now. But, last year, 2 years ago, we brought panelists to this conference from all over the world, and it cost a hell of a lot of money to actually bring them in, the cost of flights, the cost of hotels. That being said, for the same thing, it also has a negative effect. The hospitality industry is suffering, and right now they're hemorrhaging seriously because whilst it may be more cost effective and efficient for us to work remotely, some industries are going to have to rethink how they work. But so that we don't lose track, Ms. Olomola, thank you for coming back to, putting on your litigator hat. A lot of people actually may not remember or may not know that Mr. Olomola, once upon a time, was one of the most fantastic litigators of his time. He enjoyed it so much. I don't know how KPMG grabbed him, but they grabbed him and they've had him for so long. And, one day I'd like to maybe attend court proceedings and just see him in action again. Now, we're forced to work remotely. Flexibility, employee flexibility is a thing of now. We've got virtual court sessions. We're holding meetings remotely. We've got electronic filing of court processes and servicing of those processes. We've had to streamline how we work. And everything has come through a digital transformation of how we do things as lawyers, all because of this now normal, this pandemic that has affected the entire world. And Tony, this is coming to you. And I mean, when the federal government announced a shutdown for Lagos and Abuja, and Lagos gave a number of directives on how that shutdown was going to work, we all had to, in a nutshell, almost shut down our businesses. We were forced to work remotely, work from home. We initiated several protocols on how that was going to be done. Now we've had an eased lockdown. There was a curfew that was given until I think 8 p.m. That has been extended till 10 p.m. or otherwise. But you almost see on the streets that it's business as usual on the streets. However, in terms of how we work and our lawyers and working remotely, I'd just like you to share your experience, Tony. And if you think, we need to continue working remotely, or we all need to go back to brick and mortar and structure for us to effectively deliver services to our clients. Tony, over to you.
Oh, yes. Thanks, Baba. And let me say, first of all, that Ajibola possibly transited to KPMG because it has afforded him the opportunity to work remotely. As a litigator, he probably didn't have that. But that apart, I must make the point that changing societal values has made it necessary. Whether we like it or not, it is already here to stay. Virtual working is already here to stay. And I'll tell you why. I'll give you certain statistics. Cisco, for example, did a survey that showed that 45% of the employees would accept a lower pay as long as it offers flexibility. Let's put that in mind. 45%. There's a US survey that says 50% of the workforce, which are millennials, will prefer jobs that give you a work-life balance than financial incentives. LinkedIn shows that 31% of users consider flexible work as important in taking a job. So whether we like it or not, for a certain demography, it is already here. It is already here. Prior to COVID-19, I would say that predominantly, we were basically testing the waters in Nigeria. Yes, some people worked remotely, some offices, some law firms did, but COVID ensured that we had to take the deep dive. Now, ask this question. a lot of us took the deep dive. We have been swimming, we haven't drowned. We've had to learn how to do the backstroke and look for all sorts of methods to get by. But we have survived. So it is evident that working remotely, it's here. And let's be honest, Baba, you're somewhere else in the world. Work has continued. I'm here. I took a teleconference this morning from people in Dubai. All of us do it day to day. So whether we like it or not, it's already here. The issue is that it works at different levels for different organizations. Now, considering that you have that large demography that really desires a flexible work schedule or a work system, the issue is, do you want to lose your good talent? That's a huge risk that stares you in the face, and we must learn to live with it. A lot of us traditionally grew up with certain systems. We're used to the fact that in order to get by in life, you need to wake up 5 o'clock in the morning, get to work out and come back. But we must realize that the system at that point in time was different. I'll give you a typical example. In Nigeria and Africa, where we are, a lot of the people who were working at that time were farmers. So why were they waking up 5 o'clock? They would wake up at 5 before the sun comes out, go and get a lot of work done. When the sun comes out, they go and have lunch there in the farms. And before the sun sets, they are home and they've closed by 5, 6. Today, a lot of times, because we're working and servicing clients across different jurisdictions all over the world, sometimes you're in the office at 11 or 1, or because you want to meet set targets. What people are saying is that, yes, while we want to achieve this and service our clients and ensure we give optimum service, can we do it in a flexible way, in a way that we can balance providing efficient service with living a fulfilled life? And the issue is this: even if you're able to meet those targets and your workforce don't feel fulfilled, you have a challenge in your hand. So, like I said, it's already here, and whether we like it or not, we have had to, COVID more or less put some of us who are on the cliff, putting our feet in to test the waters, right into the waters, and we must go ahead with it. Now, there are also the issues of the productivity and time management. I ask people a lot of times, and I think the issue is that there's this notion for some of us that if people work at home, they won't be productive, they won't do the work. But I tell people, what do you really want in terms of from your workers? Do you want productivity or do you want activity? I think that's a question you must ask yourself. If it's productivity at the end of the day, I think we should be able to work with a lot of flexibility. The concern for me should be that it should be in a way that will maintain the ability to collaborate with one another, particularly in commercial law firms, where once in a while you want to bandy ideas about, and you need that human interaction. But like I said, it has come to stay in different variants. It depends on your own organization, but the earlier we start changing those notions and perceptions, the better for everyone.
Thank you so much, Tony. Now, this is to participants and attendants of this conference. We actually have a number of polls. If you go to the polling tab, there are a few questions there that are directed to this session. Please feel free to answer the questions. Tony, you touched on productivity and activity, the efficiency of how our lawyers work, which ultimately should translate to client satisfaction. Where that client, however, is not satisfied by your productivity or activity, then your business could possibly be in trouble. And I'm going to come to Jibola with this now. What would you tell me, and how would you tell me how and why law firms should at this point in time proactively connect with their clients, possibly pivoting on technology to match the dramatically changed agenda? I mean, once upon a time when the practice of law and the lawyer was looked upon, I mean, the lawyer looked upon himself as, I mean, lawyers are divas by their very nature. The client was supposed to visit the lawyer's office, and the rules of professional conduct actually bar you from attending your your clients' offices. You were supposed to be visited in chambers. But nowadays, we have a now normal, a next normal. We have no borders. Client engagement to ensure that they continually be satisfied with our services. Mr. Lomola.
Thank you very much, Baba. And it's a very instructive question you ask, and it follows on from what Tony was describing.
Sorry, Jibola, you're muted for a few seconds, so if you just track back and start again.
Lovely. I hope I can be heard now. I was just saying that it's a very informed question, and it follows through on the comments Tony was making a few seconds back in terms of the manner in which we engage with clients. And lawyers, of course, are a different breed of professionals in the sense that our engagement with clients is not entirely at our discretion. It's also circumscribed by rules of professional conduct that, in a sense, circumscribe the manner in which we will typically reach out. And we still have some arcane rules, or forgive me for saying so, but looking in from outside, we do still have some of our rules that need to be updated. For example, we're prohibited from advertising. We're prohibited from taking a bit more aggressive measures that some other professionals are able to take in reaching out to clients in a dynamic environment. So how are we going to compete as lawyers? How are we going to find clients if we're all stuck at home because of COVID-19 and the changes in the world today? How are we going to meet new people if we're not even able to do meet and greets, wine tasting events? I mean, the traditional way in which we typically meet new clients and sell our services. So if we're going to be engaged in remote hearings, to what extent can judges even become familiar with the dexterity and the skills that lawyers bring to the table? Because judges sometimes also make recommendations of brilliant lawyers that come before them, whether when you're applying for silk or when you're doing one or two other things in the profession that helps you get a leg up. So you find that we may need to engage with the bar to have a review of our rules of professional conduct to enable us update them and bring them into the modern world. On our own part, we must recognize, like Judge also correctly said, that things have changed. I've been home since March the 13th. I've got a team of 250 people in the tax and legal division where I sit. And of that team, I have not laid eyes on any single person since March the 15th, physically, but we've interacted online, remotely. There are clients we've sent messages to after the lockdown was eased, requesting for physical meetings. And the clients have said, why can't we do this by Zoom? Why do we need to sit in Lagos traffic and have people? In fact, there was one conference we had, and the client didn't realize it was still on video. And he was there, you know, in his casual way. The guy was just living life, man. But we had serious business afoot. And I tell you, like Tony also correctly said, it's not been easier. My working day starts at about 7:30 a.m. when I have my first Zoom call or Teams meeting. And as of last night, for example, like my last meeting ended at 11:30 p.m. So you find that the work is not any less stressful. You are dealing with one client after the other. So we're going to have to embrace technology. The other comment I'd like to make before I yield the floor is that meeting clients is just one end of the spectrum. It's a spectrum that we can control better because the clients themselves are also going through the exact same changes we are going through. So in a sense, they are willing to collaborate with us. They want to meet with us. They want to talk about their problems. They want to get our legal solutions on board. They will be our partners in that journey. There are other marketplaces that we've got to worry about. I'll give an illustration. You want to undertake a corporate restructuring today. You've got to deal with regulators. Can you engage with the FCCP online? Can you engage with SEC, the Securities and Exchange Commission, online? Can you, I know the Corporate Affairs Commission and Abubakar has been very, very hardworking and his predecessors in that regard. But can you engage with those guys online? So again, we've got to make sure that the marketplace is developed in such a way that we can actually be effective in this new normal that we're all seeing. Because if the government does not invest in the tools and resources that will make it possible to work remotely. And don't forget that physical interaction is also an opportunity for, or if you like, it's an enabler for certain practices that are not properly to be mentioned in an atmosphere like this. But if you remove or limit physical interaction with public officials, you also remove gateways to corruption. So we need to encourage the government to adopt measures that will bring government business online. Because if we do that, we can also make it easy for lawyers to interact in the new normal. The last bit of it that I will mention before I yield the floor to you, Baba, is in relation to collaboration, which Tony also alluded to. Collaboration means that if I think of the individual who wants to work remotely, professionally, on flexible working terms, does that individual need to be tied down with a contract of employment? I suspect, especially if you also think through the changes that are going to come with 5G technology adoption and the speed of information, speed of transactions that are going to come, that you'll find that the traditional law firm may change in terms of its constitution from an assemblage of professionals with diverse skills to a simple core that is then fueled by collaborative arrangements. Let me try and make this simpler. So, Baba, why do you need to have 20 lawyers in your law firm if you can, because you need to have people dealing with federal high court matters, specialty in insolvency, specialty in litigation, specialty in real estate matters? What if you didn't need to have people in your office doing that? If you could simply have a collaboration with professionals across Lagos State who can provide you services on a just-in-time basis to service all those areas where your clients have needs. And those professionals are not tied to your law firm. So they can render a service to you for client A today and render a service to Tony and his law firm for client B tomorrow. We're just propagating by leveraging on skills and specializations. I suspect that that is the direction that law practice will go. Not today, not tomorrow, but over the next 10 to 15 years. And it is the direction that most professional services organizations, even like KPMG, will go, where you will find that most of our people will not actually be employees of the firm, but will be people we collaborate with on account of specialist skills that they have developed in various areas of enterprise. Thank you, Baba.
Thank you so much for that, Jibola. I'm not sure if that was a cue on right sizing imminent or the possibility of opportunities arising. But Tony, I'm going to come to you very shortly on something Jibola touched on, which I actually want us to talk about, which is in respect of regulations that affect our industry, particularly alternative business structures that we could have, which personalities like Jibola are enjoying under the umbrella of KPMG. But Doc, Tunde, now we've got an economic downturn globally. Our legal market is facing incredible competition, not just within law firms in themselves jostling to own a share of the market. You find other industries also creeping into our space. And Jibola said we should collaborate, we should cooperate, we should have all manner of assistance or all manner of cooperative, collaborative efforts amongst professionals to get work done. I see other industries trying to poach and grab a huge share of the legal market. Am I a protectionist? Perhaps I still am. I don't have 230 lawyers and tax practitioners working with me. I run a boutique practice. How can a firm like mine leverage on technology and social media to, one, attract the best clients, and two, retain them? Tunde.
Thank you, Baba. And just to your point, the first point, I don't think...
Tunde, you're muted.
Can you hear me?
Yeah. You're good.
Okay, good. Sorry about that. I don't think it's something. I think all lawyers. Any lawyer worth his salt wouldn't say that I'm not. Yeah, they're not protectionists. I think the nature of professions generally, and it always takes me to something that I heard in probably 15, 16 years ago, one of my first classes as a lawyer, where it says every profession is a conspiracy against the laity. So essentially, every profession creates a system that excludes others because they have to protect themselves. So by the nature, the legal profession is protectionist. So I don't think it's something to be ashamed about or something to shy away from. We are protectionists. That's why we have a Nigerian Bar Association, to protect our own interests. Now, that being said, I think, yes, other professions and other sectors are starting to encroach on the legal space, primarily in other countries. And it's okay if the legal market and sector is developed. Some like the UK, like the US, they have well-developed legal markets. And so when you start to see encroachment, it is so as to make things more effective. And so from the Nigerian perspective, we still have a largely underserved and underdeveloped legal market. And so it's almost like we have a small cake and other people are trying to eat the cake. And so that's why we have that mentality of, oh, let's keep them out. I think we need to move to a system where we start to enlarge the size of the cake. And to that point, I think there's the concept of something called the latent legal market. And the latent legal market in countries like Nigeria is wide. And what is the latent legal market? It is this concept of there are a lot of people who have legal issues, but that they are not being addressed, either because A, they don't know that those issues are legal issues that can be addressed, or B, there isn't a system in place for them to be able to access it because maybe from cost perspective or other perspectives. And so when we see innovations around the law, it should be around ways that we can enlarge the legal market, the latent legal market. So that's just one point I wanted to make about the protectionist point you made. Now to the second point that you had, which is around what can lawyers do in this day and age to leverage technology and things like that. I got qualified in 2009, so about 11 years ago. And the legal market in 2009 is different from the legal market in 2020. For instance, access to knowledge, was very, very limited. So if you wanted to, oh, I have this transaction that I'm working on, there's very few people that you can reach out to that would have had experience in that transaction. For instance, I had the privilege of working in one of the tier 1 firms at that point in time. And so by and large, a lot of difficult, quote unquote, difficult transactions, there was always somebody that you could lean on to. But if you didn't have that experience, if you didn't have that network, you would essentially be floundering. That has changed now. In 2020, you can go online and you can do an online course, and then you can get that knowledge. So to start with, every lawyer should start to build up their knowledge base, use technology to level the playing field. It's not that the knowledge isn't the preserve of just one certain sector of the market now. It's open to everybody. So you have nobody to blame but yourself if you don't access it. I know someone that has been doing an online master's degree. For instance, you don't physically have to get on a plane and go to another country to do a master's degree, which wasn't the case in 2009 when I did my master's degree. So that has changed in certain ways. And so just to make that point, I'm not saying that there wasn't online learning in 2009. I'm saying that it isn't as ubiquitous as it is now in 2020. So the first thing that people can do is leverage the technology to be able to build up their knowledge base. The second thing is that you need to be able to, now I think Mr. Olomola mentioned the fact that we are robbed of having those opportunities to be able to network and to kind of service your clients and let them know, meet new clients and kind of hobnob them. But the reality is that this technology and social media and all these things gives you a wider canvas for you to be able to quote unquote market yourself. And the way that you do that, and bear in mind, I said the first step is to build up your knowledge base. If you jump to step 2 without having the knowledge base, you have yourself to blame. So once you get your knowledge base up and then you know what you're talking about, you're becoming an expert in the knowledge, not in actual practice, but in the knowledge, then you can start to share this knowledge. And this is what legal tech and social media does. I'm seeing a lot of law firms starting to engage with their customers, their clients, and engage with potential clients via newsletters. There's a couple of law firms that are using it very, very effectively. And newsletters isn't just about talking to clients, it's about telling them what is going on in the industry. Oh, this new regulation has come out. This is how it affects businesses in this sector. This is a proposed legislation that's coming up. This is how it affects them. So sharing that knowledge, standing out as a thought leader. So there's law firms that are doing that from the perspective of newsletters and things like that. It's not just, oh, we're going to get on the platforms previously that you would go and then put a long form article and then hope that the lexicologists and all the other stuff of this world. Now it's changed. If you have a customer's email address, customer's contact details, it's gold, because you can open up that communication and control that communication with them. So that's what you can do from a law firm structural perspective. But even as an individual, because a lot of people that are joining us here today are maybe just younger lawyers that are just starting up, or people that have their own just one-man law firm, a two-man law firm, there are things that you can do, because in that sense, you're not selling your firm, you're selling yourself. You have to start to stand out as a thought leader. So there's being a thought leader and then just being someone who just badges online. Being a thought leader is about being more focused about what you put out about yourself and the content that you put out. So for instance, maybe this recent Supreme Court decision about virtual court hearings, that's very topical. You can, if you have a following on Twitter, on LinkedIn, or Instagram, or whatever, share your thoughts on, okay, this has come up and this is how I think about it. So you are making engagements about and standing out as, oh, this person is a lawyer, they have nice ideas about different things. And so and because I'm an entrepreneur in one sense, I'm coming from a marketing speak as well, because what you're doing is something that's called top of mind marketing. So every time, they might not need something now, but they might not need legal services now. But the fact that they know that, oh, this person has always been banging on about entertainment law, banging on about tech law, whatever it is, and you are at the top of their mind at the time that they need that service, and so they go to you. So to your question, it's all about putting yourself out as a thought leader, getting the knowledge and engaging with your clients from a professional perspective. But also what tech does, and what I'm starting to see that a lot of law firms are starting to do in Nigeria, and I hope it continues, is that similar to what like the banks do. So it was my birthday recently, and I have, like, as with most Nigerians, I have like 6 or 7 different bank accounts, and 6 of them sent happy birthday messages. The 7th one that didn't send, I said to myself, why didn't they send me a message? And so it's like, I expect it now. And that is where we should be going as a law firm. You should start to build that relationship with your clients. And I'm not saying start sending out text messages to them, but you can use a CRM that you have the database of your clients. You have the lead person you're dealing with. You have the person's date of birth. You have you structure, okay, we're going to send out a message on Independence Day, and a lot of people do it. I'm not saying they don't, but I'm just saying we need to make it more of a culture. On Independence Day, on Democracy Day, Christmas, Easter, the Muslim holidays. And it could be, yes, you send out automated stuff, but if you get a notification on your CRM that, oh, it is Baba's birthday coming up, let me give him a call. Imagine how your client feels if you give them a call on your birthday. And all this has done is just because when you signed them up, when you were doing your KYC, you got their date of birth. They will be surprised. And also there's know-how, that builds that connection. So technology makes all these things easier. So even though there's the bad aspect to it, there's always a good aspect to it. And so it's important that as lawyers, we start to use those tools to be able to, number one, engage with our clients and show off our expertise. And number two, make sure we use the tools to be able to create that connection. Maybe not as intense as the banks, but similar, where we get some kind of engagement and let them know that we haven't forgotten them. I think a good kind of touch point, maybe if you can reach out to your customers, it doesn't have to be there's an active case going on, but if you can have like 6 or 7 touch points with your customers over the course of the year, then they don't forget about you. If they don't forget about you, then they'll come to you when they need you. And if they don't need you, they'll come to you when someone that they know needs you. So that's the way we need to start to reprogram our minds around that. So that's
Thank you so much, Tunde. I think that's been highly informative. You've helped smaller business like mine. You've more or less told us how we can compete with the giants like Jibola's business, and how we can compete with George's business if and when they intend, or if and when they do come to Nigeria. George, yesterday when Nigel Boardman was speaking during his session with Maima, Bolaji Balogun, and the rest of them lot, he raised a point which I'd like you to touch on. And this is about pricing and billing and fees from law firms to existing clients and even prospective clients, and how we should bill. Now, because of the times that we're in, yes, cash is king, but not a lot of people have monies in their pockets. A number of businesses, whether they are startups or otherwise, are struggling. Now, in terms of pricing, how would you say law firms should reinforce their value proposition and position themselves for when the economy recovers? I hope I wasn't muted.
No, you're not muted, and I hope I'm not muted as well. Can I just, in answering that, pick up a point that Dr. Tunde made, which is really about the way in which we charge for things and the collaboration that we have with third parties and the way in which we show value. One of the things that I think is a real difference between when I started in practice and now is the unwillingness of clients to pay for certain things that lawyers used to do traditionally. And one of the key areas where the electronic age has changed things is in disclosure or discovery, where actually it used to be the case that clients would pay for teams of lawyers to sit in banks of either in front of files or in front of a screen, actually reviewing physically all of the documents, and they won't pay for that now. And I think the next thing that we've got to address in a way is the disaggregation that is happening at the moment as a result of all the things that we've been talking about. So I think that clients are going to turn around to us fairly quickly and say, you occupy these great big offices that various of the panelists have been talking about, but actually most of your people can work from home, or they can work in sort of different or remote areas. You only actually need the offices to come together for an occasional meeting, team building, whatever it is. We don't want to have to pay for that. So I think demonstrating that value proposition has actually become incredibly difficult, and it becomes more difficult when you're doing it remotely and you're doing it in this kind of way. I think one of the things that is certainly I agree with Dr. Tunde on is that you need to have that contact, whether it's on Zoom or however it is happening, in order to demonstrate value. So in other words, if a client is not really conscious of what it is that you're doing, they're not going to be willing to pay for it. But when it comes to actually reinforcing that value proposition, actually showing that you're aligned with the client, what I am seeing across most of the world actually is an increase in the desire of clients to have risk sharing or funding or some kind of way in which they can defer paying the fees, where you as the lawyer are sitting alongside them. Now, it's too big a subject for the amount of time we've got left to start talking about litigation funding. But what we are seeing most definitely is an increase in the number of clients who come along and say, well, we want to instruct you, but we're not going to pay those rates. What we're going to do, or what we will be willing to do, is to pay a reduced rate with some kind of enhanced rate on success. And we are having to be, I think all law firms in the UK and the USA and what have you are having to be very open to that kind of proposition, because the traditional, as you say, the traditional hourly rate model is becoming more difficult for a lot of clients to justify. We see variations on it. We see caps, we see collars, fixed fees, all sorts of things coming in. And we are having to be a lot more sprightly in terms of actually accepting those kind of arrangements. You know, that's a reflection of the competitive position and the competitive market we're in. Bye-bye.
Thank you so much for that, George. I mean, time's fast spent. It's critical for us to stick to time. As you find, this conference started exactly at the dot of 10 o'clock. Similarly, yesterday, I mean, there's no Nigerian time here. SBL, you just keep pushing it, and you know, you keep setting the pace. I'd like to see this happen with the main body of the Bar Association's conference next month. As we're running out of time, I think it's important for us to go into Q&A now. We may not be able to take all the questions, but we'll take as many as we can. The rest of the questions will be posed to the panelists, and they will respond either via this the Hopin platform or directly through emails. So if the people that have sent their questions don't mind also sending their email addresses so we can get back to them. I'll take this first question, and it's to Jibola Lomola. And it says here, at Jibola Lomola, though the online platform will help curb corruption, considering the present dispensation, I have seen that despite this online platform of some government agencies, what we find is that rather than officials doing their job, it is the opposite. What do you propose can be done to stop this? Jibola, I don't know how you're going to affect public sector doing their job working from home.
Well, ultimately, let's not forget that the...
Oops, you're muted. Sorry, this is part of the challenges of tech. You're still muted.
No, we can hear.
Okay. Right. So the Bar Association and lawyers generally play a significant role in shaping government regulations and government practices. We've seen the efforts of the current Attorney General, the Honorable Attorney General of the Federation, to instill accountability in certain aspects of governance. We also know that this government is making very serious attempts to look at governance of public institutions. I think the question is a very good question, because government is, if I were to hazard an estimation, government is at least 40% of what lawyers deal with in terms of their of our activities in the legal profession. So if we can get the government to work properly, if we can get the online method of dealing with government to work properly, and the interfaces with government to work seamlessly, it would help. Part of what would help would, for example, having a database where you can actually communicate with the government officials you're dealing with. So if I file an application as a CAC and I'm having some delays in having my resolutions filed, for example, or my CAC forms returned to me and certified, who can I contact there without having to physically get up and go to the CAC? It shouldn't be that I have to call the Registrar General. Now, if I can see online which officer is my scheduling officer, and if the online portal also allows me to have a chat with the individual to understand what the stumbling block is and to follow up, it will remove the need for me to send a young lawyer to the CAC office to go and follow up. Same thing if we are dealing with the lands registry. For those who work in perfecting titles, why do you have to go up and go to Alausa and go and follow up on your title document if you can interface with the government official online remotely? So I think government can invest in technology. Government can invest in platforms that allow the public to interact with government officials remotely and to get answers to their inquiries real time. I think that would really help a lot. And when officials can be identified, you find that the tendency to be corrupt is also discouraged, because nobody wants to be embarrassed. So I think bringing that level of transparency to the manner in which we deal with government will address the question that has been raised. Thank you very much.
Thank you so much for that, Jibola. I'm going to take the next question very quickly. It's come from Temi Orekunri. And Tony, that's coming to you. Says, if working from home becomes more of a norm, how do law firms plan to ensure there's a level playing field, considering the fact that lawyers will be from different backgrounds? And the focus here is some with easier access to electricity and or internet. And this is very key. Tony.
Yes, thank you. It's a pertinent question, but
you were muted. Tony, you were muted, so just start again.
Okay. Am I on now?
Yeah.
Okay, thank you. It's a pertinent question, but for me, it still lies and is tied to what you want as a practitioner. And I ask this question all the time because there are too many questions bandied about by lawyers making it look like we need help. Yes, we do need help, but first of all, if you have the mindset that you're running a business, like any other business, whether it's the person running a small shop on the side of the road, whether it's the person running a garage for an auto garage, you want to be able to provide services to your clients. If that's what you're in business for, it must be in the back of your mind all the time. So if power is something that's necessary for your business, if you don't have a business plan that takes that into consideration, you're already working on a false premise. I'll have to say that. Yes, the NBA can sit down and think of innovative ways and the profession about how you can get across. But the truth is this.
Sorry, Tony, let me interject quickly. I think where Orekunri is coming from is with lawyers within a law firm. So we've said, go and work from home. We're working from home. I want to protect you. I want to make sure you're fine. This is health and safety now. But I haven't bought you a generator. I haven't bought you diesel or petrol. I haven't given you a MiFi. How does it become a level playing field for all of them?
Yeah.
Okay. Thank you very much. That's a pertinent question. Let me say something. I think the season we're in has given us a very good opportunity to consider that question. And I'll say something. We ought to have started auditing, if you're not auditing as a firm, to look at how all these issues have affected your ability to render services. And I will say that if you haven't started that, that problem is going to wait for you down the line. The issue is that you must first of all do an audit. What has worked? What has been the challenge? What have been the challenges? Are there people who have been able to effectively service your clients more because they readily have more internet or power? But I think it has to form the basis of policies that we're going to lay in place going forward. The new normal is that a lot of work is going to be done offsite. All the challenges are going to be there, but every institution must actually carry out an audit of how it will be able to actually effectively provide service. So to provide a level playing field, you first of all have to audit and know what exactly are the challenges in your own organization. Is it that you want to have minimum standards that you put in place for everybody? Like for example, for us, we decided, when the pandemic started, that we would provide some kind of allowance for internet services. But you must sit down and also consider issues like, are there specific teams that actually require more data by the nature of their work than others? And these are constitutions you must put in place. But the thing is, like any other business, you must sit down and look at the data and the statistics about these issues. And I dare say that if you need outside help, get it. I think lawyers are not in the habit of doing that. I was glad to hear Baba say he had worked with Tunde before on some issues. The issue is whether we like it or not. It is there for us. It's going to steer us down the line, and some of us are going to be left behind if we don't do what is necessary. But like I said, the first thing is that you must take an audit. If you've not done that already as a firm, I can tell you clearly you're already behind, because if at the end of the day, what you'll be doing is catching up. It's staring us in the face whether we like it or not. As we work today, we're faced all these issues. There are employees we see sometimes that their own environment have more difficult issues relating to connecting to internet. But like I said, every business must look at its own situation, consider what is the required infrastructure you need in order to effectively provide service to your client, because at the end of the day, that's what it is. So I dare also say, going forward, those might also form some of the considerations you might want to think about, even in hiring, because we must be able to effectively service our clients. If you think that there are people in certain areas where it will be almost impossible to do that, even if you desire to deploy the infrastructure, it means we must actually take a good look at the long picture and deal with it. Thank you.
Thank you so much for that, Tony. Ijeoma, this question is coming to you, and it's very relevant because this panel is supposed to be zooming ahead, the law firm, law practice post-COVID-19, which means how we're all supposed to leverage on technology and taking us to the next level. Question comes from Nanda Esmeralda Ndam. And Mr. Ajibola says, please, are you suspecting that we will be downsized and having employees will be irrelevant in the future? I believe this is in relation to AI, chatbots, tech. Is the lawyer still going to exist in the near future, or is everything going to be done by robots?
Very good question. We probably won't have enough time to just disambiguate it, but we can probably have a conversation after this session is over with the questioner and go into more details on it. However, the thing to bear in mind is that there will always be a role for lawyers and there will always be a role for people. We can repurpose the skills that are required, but human intervention will always be required, because when you're interfacing with matters that arise in human interactions, you will always need a human being to interface. But your question is also very instructive, relating to the question Tony just answered and a comment Benga made in terms of our ability to recover fees from our clients. If you think about it, our costs, what we charge our clients, is a reflection of our costs. And our greatest costs are the salaries we pay our staff. Now, today, we can save on rent because we may argue that your staff are working from home. So why are you paying all the fancy rent you are paying in VI, in Abuja, in Kano, and so on and so forth? So maybe our needs for physical infrastructure may need to be audited, like Tony suggested, and any cost savings that we achieve from that review can be passed on to our employees. We already know that the young lawyers feel that they are not well compensated by law firms currently. So maybe if law firms are able to save more on their infrastructure costs because they are now leveraging more on online resources, they'll be able to put more money in the hands of their staff. They'll be able to spend more money on training their staff, which means that the staff acquire more skills and are more relevant and therefore able to participate more. So I don't think this needs necessarily to result in a loss of employment. I think it will actually lead to lawyers being very more repurposed and able to intervene in very more areas than they traditionally would do. So maybe the day of the general practitioner is slowly winding to an end, but you will find that a general practitioner with very specialist skills in 1, 2, or 3 areas will continue to be very highly sought after.
Thank you so much for that, Jibola. Next question is going to George. George, this question has come from Lolade Tijani. She says, thank you for sharing your perspective from the UK judiciary. I would like to know what your thoughts are on the risks of hacking in a private arbitration hearing and how to curtail this risk. So I guess this is more in terms of security and as well privacy. George.
Can you hear me, hopefully, Baba? See if that's working. Good. So this is a really good question. And it has been an interesting journey within the UK because actually, funnily enough, the judiciary itself has not been too concerned about this question of privacy. So what they have done is allowed the use of platforms such as Skype and Zoom, even though those platforms are not, as it were, certified as being entirely safe and secure. And the reasoning has been that actually for most of the hearings, they will allow up to 500 or even more people to have access to the hearings anyway, because they're public hearings. Now, arbitration creates its own difficulties. And when you look at Zoom, for example, which is the arbitration platform which is being preferred by a lot of the LCIA arbitrators, it allows the arbitrator to put people into private rooms. And the demonstrations I've had have been pretty good in terms of the privacy within those private rooms. So a particular team will use its private room for a discussion about how it's going to cross-examine a witness and so on. The reality is that none of that is safe at the moment. So it's a bit like, Baba, the comment you made earlier on. We're in the foothills of this, and the technology providers need to understand these kinds of issues and actually overcome them. They're using products that were never designed to be court-led products, but they're applying them pretty well at the moment. And they've expanded, for example, the number of people who can sit in and watch a hearing in order to kind of accommodate the requirements of the justice system. But they will need to overcome this issue in relation to privacy and hacking. And what we have done, because we've been very concerned about this question, is that we will do a hearing, but we will set up an entirely separate parallel system. So we will have, and it can be as simple as having a WhatsApp group on your phone sitting next to the screens that you're using during the hearing, so that your communication with the rest of the team is not using the same platform. So there's no direct link that somebody could get into. But I do think that it's something for the technology providers to do more on, because we're not there yet, and I don't think as practitioners we can be satisfied just that all of that is safe. I think it's a real risk. Can I just take 1 second just to mention something else, which was in relation to something that Mr. Olamola said earlier on, and that is in relation to hearings and the way in which they might operate. As I said, this sort of really basic thing of having mirrors behind you and things of that sort. Those hearing centres that he suggested would be set up do exist. They exist quite extensively in the Middle East. They exist in London. They are being set up for exactly the reason he identified. And in India, when you look at this question of how people are going to access justice, what they have done is to have, for example, in the banking sector, an adjudication process set up online that people can access through a mobile phone. And they've taken it outside of the judiciary because there's such a backlog of cases. There's such small cases, but there's such a backlog of cases that they can't do it. And I think there's real opportunities there for market entrants to identify particular industries and particular sectors where that kind of approach will work, and it can be done. It's rough and ready justice to some extent, but it can be done, and it is being done in some jurisdictions. Bye-bye.
Thank you so much for that, George. The next, I have a comment here from the SBL's Vice Chair, Ayuli Jemide, and he's touching on, he's literally just, it's an observation on the point Jibola made. He says, the point Jibola makes has been tested with success in the UAE. Nearly all licenses are obtained online with no human contact. So hopefully we should be able to do, full stop, actually, that was his comment. And this is me saying, hopefully we should be able to get this across board from our regulators, particularly the ones in Abuja, from the CAC. Bolaji Balogun mentioned yesterday during his session that he hasn't wet ink signed the document in 2 years with a bunch of instruments that have been filed with the SEC. And they've been doing their filings throughout this period and beyond electronically. So I believe this is the direction we need to zoom ahead with legal practice. Time's far spent. I'm insistent that we keep to time and that we close in the apportioned time that we were given. Again, a reflection of SBL setting the pace. To my panelists, I say a fantastic thank you. You've been phenomenal. You've been very, very insightful. Thank you, George, for purchasing the ticket and flying out from Paris to join us in Lagos. Jibola, thank you for driving down. Sunday, you'll be able to get home pretty soon, I hope, when the sky is open. Tony, thank you ever so much. One more thing that I wanted to let the audience know. One of the 5 of us actually participated, or did not participate, participated and masqueraded as a DJ and MC for 4 weeks, successfully convincing experts in the music industry that he was a proper professional DJ. Can any of you guess who it was? It would be nice to see that, typed in the chat room. Thank you all so much for a fantastic session, and I'll just let the panelists close out with closing remarks individually. Jibola, do you want to start?
Thank you. It's been phenomenal spending this time with you and sharing my views and also listening to this great assemblage of mind. I hope the conversation will continue after this. Have a good day, everyone.